Mitt Winter has been on our show before and is an attorney, and you can follow him at Winter Sports Law at Kenny Hertz Perry LLC, a college athletics attorney, covered NIL and lots of different things. But Mitt, you had a fantastic tweet thread a couple of days ago that summarized of what can be it's going to be a very lengthy process when it comes out of House versus NCAA. This is by no means a cure-all, and if the settlement does get accepted, you've kind of pointed out things that will probably happen along the way. Do you believe that the NCAA and the P4 believe that this will start a cure-all, or do you think they're aware of these things?
I think they're definitely aware of these things, but they're hoping that some of these things can be dealt with either by help from Congress, by giving them an antitrust exemption, which they've been asking for a number of years, or that the way the settlement is structured will dissuade some of the potential lawsuits that would still be able to be brought against them. So they're definitely aware of these things. It's just a question of how much do they actually believe they're going to, number one, possibly get an antitrust exemption from Congress, and then number two, how much the way the settlement is structured is going to prevent future similar types of antitrust lawsuits from being brought against the NCAA, because the way the settlement's going to be structured, if it does end up going through the way it's being talked about, it's still going to have a cap on compensation that the schools can provide to the athletes. Right now, that cap is zero. That cap is going to be moving up, by a lot, $22 million, but it's still a cap, so it's still vulnerable to antitrust attack.
So what is Mitt, just because we go from this settlement happening and on the verge of happening, only two conferences have voted to move forward so far, so the other three remains to be seen. But is it just the element of getting rid of the back payments that's the actual good news here for the schools? Granted, there's a lot of questions, as you point out, that still will come no matter what happens here, but is that kind of the positive that they're looking to take out of this, is just the back payments more so than anything else?
Yeah, that's a big part of it. If you're talking just about the House case, potential damages could be around $5 billion. And then when you add in the Carter case and the Hubbard case, which are two other big class actions pending against the NCAA from the same plaintiffs' attorneys in House, you add all those three cases together, and the NCAA has said, well, we could be potentially on the hook for $20 billion with those three cases combined. So if you're only having to pay $2.8 billion, that's a pretty big discount on the potential $20 billion. But then also by agreeing to engage in some revenue sharing, by allowing schools to pay NIL compensation directly to athletes, it does buy the NCAA some potential goodwill with Congress, and then also prevents the plaintiffs' attorneys in these cases from suing the NCAA again. So there's in addition to that, reduced damages number, it is going to provide them some benefit going forward.
Mitt, you mentioned that the NCAA is kind of hoping this will allow them to eliminate collectives, but I don't see how that would be the case. Like, even if you do bring NIL and have a payroll for the athletes, that still doesn't, eliminate the fact that those can exist, and no court has made any kind of determination any other direction so far that collectives can't exist and can't enrich athletes in any way they see fit.
Yeah, I agree with you. This settlement is not going to eliminate collectives. I think what the NCAA is hoping will happen is two things. One, they're hoping that when schools are able to directly pay NIL compensation to athletes, the donors will want to just give to the school now instead of giving to the collectives, because giving to collectives is really their only option now if they want to pool a bunch of money together and get it to the athletes. But if they're able to do that through schools and get their tax deduction from giving to the schools like they do for other athletics things, a lot of schools and conferences in the NCAA are hoping that they'll just do that. And so then that will dry up the funding source for collectives. And then I have heard that coming out of the settlement, there's going to be a move from at least some conferences to really try and punish schools if collectives engage in what the NCAA and some of the conferences perceive to be the pay-for-play type of NIL deals. And I don't like you said, this House settlement isn't going to magically make it easier for them to enforce their rules or make it more likely that a court will say that rules that the NCAA has regarding NIL and boosters don't violate antitrust law, like we saw with the Tennessee case. That was a case where they were going to try and crack down on a school because of what a collective did, and the state sued them, and the court agreed that the rules they were trying to enforce violated antitrust law. So this settlement's not going to solve any of those issues. And to your point, I do think there will be plenty of collectives that stick around because with this revenue sharing cap from schools to athletes, there will probably be some schools that hit that cap, and to be competitive in recruiting, they might feel that they need to go above that cap, and that's where collectives would come in.
You also mentioned Title IX. This has been a confusing thing about all of this. And so $22 million is not just for football. That's $22 million across the board for all sports, correct?
Correct.
So that has to be distributed amongst the other athletes. And granted, football is going to be the one that has the largest chunk of that. But how do they distribute it? How do they make it equitable under Title IX and fit under what is ever-growing list of things that fall under Title IX, seemingly year after year?
Yeah, and you can get lots of different opinions on whether Title IX is going to apply to this NIL compensation being paid from the schools to the athletes. Some people say it definitely does, and so schools need to be basically dividing those payments up 50-50 between their male and female athletes. Some people say Title IX does not apply, so you don't need to worry about it. Some people say it might apply under part of Title IX, but it still isn't going to mean that you need to divide those payments up 50-50 between male and female athletes. So I think you'll see schools taking a number of different approaches based on, what their risk tolerance is and what their Title IX compliance might already look like and what their history of potentially being sued for Title IX violations is and just how worried they are about Title IX. So I think you'll see a lot of different approaches there, but no one has a black and white answer on that question. And I think there definitely will be some Title IX litigation once schools start paying this money out to athletes. There's a plaintiff's attorney who has brought a number of Title IX lawsuits against schools on behalf of female athletes, and he's already come out publicly and said, I think Title IX definitely applies to these payments. They need to be going 50-50 or in proportion to whatever that male-female athlete split is. And so I could see him, definitely bringing some lawsuits.
How do you see the contracts between schools and athletes working out? Because they'll have to have them when it comes to direct NIL compensation.
Yeah, that's an interesting thing. So when you think about it, at a big school like take Ohio State, I think they have like 30 sports. And if we assume they have an NIL agreement with all of those athletes, you're talking hundreds, maybe even close to thousands of athletes. I don't know exactly how many athletes they have at Ohio State, but that's a lot of contracts that are going to have to be managed between a school and its athletes. And again, there's some different approaches that schools can take there. I've heard some schools are going to want to try and enter into agreements with athletes where they acquire exclusive rights to their NIL rights, or at least exclusive rights in certain categories. They could do it non-exclusive. There's all kinds of different ways. They could use third parties that are paying the athletes for appearing in marketing content on behalf of the university. So I think we'll see some schools get creative with what those contracts look like, which will be another interesting thing to watch. And with everything in college athletics, schools try to do things that help them in recruiting. And so how you're structuring these agreements and what athletes might have to do, I think that will, vary from school to school. It's really interesting to see what they do there.
Also, when it comes to the employment push, kind of to go with that, that's not going to really slow down that either, is it?
No, it's not. So, yeah, this House settlement will do nothing to address the employment issue, which is still going to, continue to move on. We've already had the Dartmouth decision with the NLRB where they said, yes, Dartmouth men's basketball players are employees and they can unionize, and the team to unionize and now is represented by a union. We have the USC NLRB proceeding, which is seeking a finding that USC men's and women's basketball players and football players are employees. Another big lawsuit called the Johnson versus NCAA case that's also seeking a finding that some college athletes are employees. So that issue is still going to be out there, and it'll probably be a couple of years till it's finally resolved. It might have to go to the Supreme Court to be resolved. I personally think that, I don't know whether it's 5 years or whatever that number is, that some athletes will eventually in the future be employees, especially if Congress does not provide the NCAA with an antitrust exemption, or college sports in general with an antitrust exemption, because if some college athletes are employees, then they are able to unionize and can collectively bargain with the NCAA or whatever other governing entity there might be at that time. And then that would make those rules that are agreed upon, like salary caps and player movement rules, things like that, immune from antitrust law. And so that's kind of the one benefit of having employment.
So is like the House settlement, if it were to go through, Mitt, obviously, like we've laid out, like it doesn't solve everything, but is it like a butterfly, bandage on a knife wound, basically? Is that basically just cutting to the chase, kind of what it is?
Yeah, I would say that. I think it kind of provides a momentary pause for schools and conferences and NCAA to say, all right, we have a little break here. We can take a breath. And then, we know there's still going to be other issues, but now we have a little bit of time to try and figure those out, whether that's we're going to intensify our lobbying at Congress for a law that gives us an antitrust exemption, or potentially look at other models. We don't have this anvil hanging over our head of billions of dollars in damages anymore. So we can, assess things with a little bit of a clearer mind.
I know there's all sorts of cases swirling, and you mentioned them, and forgive me if you mentioned this already, but Alex Fontenot, the former running back who's suing the NCAA and all the various conferences, I noticed a couple of tweets that you had about him, and I just haven't seen that. Me personally haven't seen him mentioned as much as some of the others. Can you kind of explain that one, and how does that fit into the grander puzzle here? Because you do mention that could kind of be a house of cards depending on how that is viewed as currently compared to the House case.
Yeah, the Fontenot case is a case filed in federal court in Colorado, and it's really similar to the Carter case that I mentioned earlier that is part of the settlement discussion. So House is seeking a finding that the NCAA rules that say schools and conferences can't directly pay NIL compensation violates antitrust law. Fontenot and Carter go farther than that. They seek a finding that the NCAA's rules that prevent college athletes being paid, whether that's from schools, conferences, or any third party, that prevents them from being paid for athletic performance, violate antitrust law. And the Fontenot case, the NCAA has filed a motion to consolidate that case with the House, Hubbard, and Carter cases so they can all be settled together, and all those cases would then be resolved from that settlement agreement. But the plaintiff's attorney and the plaintiffs in Fontenot don't want that to happen. They want their case to stay in Colorado so it doesn't get settled by this House settlement, and so their case can potentially move forward separately. So I know that the House settlement talks, people are agreeing to settle this case based on the assumption that Fontenot does go away as part of the settlement. So if that's not the case and Fontenot is not consolidated with the other cases and it's able to move forward, that could throw a wrench in the House settlement.
What are your thoughts on private equity making its way into college athletics?
I think it's going to happen. I mean, there are a number of articles that you guys probably saw today about a group that's gotten pretty far down the road in some talks with some schools about basically they're going to infuse them with a large amount of cash, $50 to $200 million that the schools can use for their, any of their athletics department needs, facilities, revenue sharing payments, whatever it is. And then the private equity company is just going to receive a royalty on new revenues that the school generates from its athletics department. So they're calling it private capital instead of private equity because they're not actually taking any equity in the school or their athletics department at all. So I do think we'll see some schools that take them up on that offer, especially some schools in conferences like maybe the Big 12 or the ACC, where they want to compete at the highest level with the SEC and the Big 10, but they know that there's a big revenue gap that exists because of the difference in their TV contracts, and that revenue gap is going to keep growing over time. So I think those are some of the schools we might see take some of this private capital.
Do you think that's a bad thing, or do you think it's to be determined?
I don't think it's a bad thing necessarily. I mean, really, it's just trading a percentage of future new athletics revenue for a big chunk of cash right now. And so it's not a situation where these outside people are going to come in, take over the athletics department, start firing people. That's what a lot of people have in their head when they think of private equity.
Me too. Yeah, me for sure.
Yeah, so that's not what this is going to be.
Mitt, thank you so much. Appreciate it. Great stuff. And appreciate the following you on Twitter, because some of this stuff is complicated and none of us went to law school in this business. I mean, here, and most of us in the media didn't go to law school. That's why people like you did, so you could explain it to those of us who could not hang. So it's really awesome that you're able to kind of break this down and let people know what it's going to be like.
Yeah. No problem. It's definitely complicated stuff, even for those of us that did go to law school and whose job is to try and keep up on all this stuff. It's not always easy to understand, and so many different moving pieces and different legal issues, but it also makes it fun.
Mitt, absolutely. Thank you so much. And we'll talk to you again the next time we get confused.
Thanks. Appreciate it.
That's Mitt Winter. Follow him on Twitter. X at Winter Sports Law. I don't want to call it X.
Yeah.